Guys, please don't lose patience with this video. I want you to see something ridiculous. When I saw this, I began to wonder, why is this being allowed to happen? The so-called advocate Mpofu is among the people who are wasting our resources within the court system. Before we begin, welcome to Citizen Concerned, where we remind you to beware of the comrades. I'm Katlego and would appreciate it if you subscribed to our YouTube channel, liked and shared this video with other citizens. Okay, so Dali Mpofu is here to present the case for why the disgraced, incompetent former public protector should get the 10 million rand gratuity from her former employment as the public protector. He wants to get the judge to say, hey, Mkhwebane deserves to be paid 10 million rand as a thank you, even though she was incompetent and found to have engaged in misconduct, leading to her being fired. I want you to notice something. Dali Mpofu makes an error in a statement and gets corrected by the judge. The judge does not spend too much time talking. He simply corrects Dali Mpofu, but soon after that, I noticed something that really made me worry. Take a look at this.
Coming out of that and forgetting the legal formalism now as to whether we're dealing with review, a declaratory order, section 172, and so on. That notion cuts across all those conveniences. Which then brings us back, my lord, to, and this is where I end what I call the overview, brings us back to the question. So the burden, for lack of a better word, on the state is always for it to provide that justification to a court of law. So it's not a civil claim for damages where just because we are the applicant, we have to establish, if we don't establish our case, well, then we must go home.
But isn't it the case that for the state to justify what the state did, the claimant in turn has to establish the legal basis to what the claimant says they're entitled to?
Of course.
So Dali Mpofu is saying it is the job of the state to prove to everyone why the state should not give Mkhwebane that big fat 10 million rand thank you. The judge corrects Mpofu and says, no, actually, it is your job as a complainant to prove that your client has been wronged. Show us how your client has been wronged, and then the state will give their counter argument. The state will respond and tell us why you are wrong. Basically, Advocate Mpofu, please tell us why you think Mkhwebane should receive 10 million rand, even though she was fired from the job which she was incompetent in. Tell us why she should get 10 million rand and a thank you, even though she was found to have engaged in misconduct. Instead of saying, I agree, dear judge, and moving on, listen to the way he wastes the court's time and the nation's time. He does not move with haste to start proving his case for why the disgraced former public protector should be given the 10 million rand. This is his response.
In turn, has to establish the legal basis to what the claimant says they're entitled to.
Of course. Of course, at least a prima facie case. So in other words, if I come and I say, well, you've locked me up in a cell, and therefore prima facie you have encroached into my right of movement. It's only then, your lordship is quite correct, only then does the burden arise on the state to then justify. Because prima facie, obviously you have restricted my freedom of movement. But that's the slight difference between a normal case, quote unquote, and one where we're applying the Constitution. And that's why we have Section 36 of the Constitution. Because Section 36 of the Constitution, in my book, is the most important section. Because it's all very well to say, I have a right to this, a right to this, a right to that. But Section 36 says, well, there are obviously instances circumscribed by law where there is a justification, where there may be, a justification for that encroachment. So your Lordship is quite correct. It's not like the claimant just comes to court and says, okay, well, justify. The claimant has to lay a basis, and once that basis is laid, particularly when we're dealing with the Bill of Rights, once that basis has been laid, then the duty to justify arises. And in this context, it arises at the risk of repetition. It arises in this context of saying, well, there is this conduct which you have done against me, which adversely affects my rights and so on. Now you have to convince a court of law that it has some legal basis somewhere. Whether it's in a contract, whether it's in legislation, whether it's in the Constitution, whatever, but it must have some legal justification. Right, so that's the canvas, if you like. Now, when we come to the actual painting, in this particular matter, we then have to look at the interpretation of the relevant instruments, which have purportedly been relied on by the state in order to perform the impugned conduct. And then the case will really turn on to, if they are able to establish from anything in law that there is such a justification, well, then they must succeed. If they cannot provide such a justification in law, not in because of feelings or whatever, but if they can't find that justification in law, then they must lose. Now, having said all that, then, my lord, let's get to the nuts and bolts.
Our judges are forced to listen to loonies like these for months or even years to make a ruling on one case. They are forced to listen to a rumbling person, all while there is a backlog of cases that need to be presented before the court.
There have been a number of complaints about these courts and accusations made that they're not, that cases that they're dealing with are not being resolved timeously.
While many of the higher courts are fairly well run, concerns have been raised about a backlog at the lower courts.
I think I know why the judges are forced to listen to this hogwash. They are scared of being called racist or biased. They must suffer fools. If I was the judge, I would have simply said, get to the point, sir. I'm serious.
All that then, my lord, let's get to the nuts and bolts. And again, the advantage of your lordship having gone through the issues here is that we can. What we really propose to do, my lord, is to find some shortcut. This case has got all sorts of byways and freeways and alternatives and further alternatives and so on. But forget all that. Let's zoom into the proper sequence. In our respectful submission, the starting point, one can start anywhere. I'm sure all my learned friends will start at different points. But for us, my lord, the logical starting point is section 2195 of the Constitution. Because it does two things which are important. It gives us the source of the gratuity that we're here about, but it also answers another question which is important around what is remuneration.
They must restrain themselves and squeeze their muscles, holding themselves back while snapping pencils in frustration at the ridiculous caliber of advocates like this man and those like him. He starts lecturing the judge on the matter that the judge has just corrected him on, as if he is educating the judge. It's a clown world. The judge just told you why you are wrong, and instead of accepting and moving on, you take longer to explain why the judge is right about telling you that you are wrong. What is going on here? The judge simply has to just sit and listen. Meanwhile, in his head, he's screaming, "Shut up and continue, man. Stop rambling on, telling me what I just told you." But he can't say it, or else the EFF and those like them will scream racism and bias. The court has to tolerate this kind of time-wasting conduct. We need cases to move and move fast. We need judges that see through this nonsense and address it as the nonsense that it is. It is a waste of time. If Mkhwebane is paying this guy, she's definitely wasting her money too. Even if she was to get that 10 million rand, she'll end up giving 90% of it to this guy because of the time he took to get it. He is wasting time. Meanwhile, many people who should not be waiting in line are waiting to get their days in court. There are people in this country who have to wait for too long to get in front of the judge. Meanwhile, Dali Mpofu with his EFF and MK clients are wasting our judicial resources. This is just ridiculous. Anyway, that's it for today. Thank you so much for watching, and thank you for listening till the end. I just had to vent about this ridiculousness. Anyway, please remember to subscribe and join the channel membership if you haven't already. Please like and share this video. I'm Katlego. This is Citizen Concerned, and until next time, beware of the comrades.